Well, I don't think anything it's quite new. It's just that there's more of a focus nowadays in terms of rights owners to adopt a more proactive approach towards enforcement rather than a reactive approach towards enforcement. What do I mean by reactive? In the past, if you were to encounter a problem, let's say in Singapore, then the rights owners will simply approach the council over in Singapore to deal with the issue. But nowadays, you find a lot of rights companies are starting from the commencement of the work year. They have a budget that's allocated and they begin to plan very strategically, allocating certain amounts towards more problematic areas, less monies towards less problematic areas. And the objectives are more strategic. So for instance, in China, it may be more towards manufacturing. In relation to Singapore or Hong Kong, it may be more towards distribution. Over in Bangkok, or Vietnam, it may be in relation to retail. So the strategies are being tweaked and they're planned from the get-go.
Great.
That's right. I mean, you see a lot of cost effectiveness in having a proactive approach. And then the service providers are measured against the year-long target that's been set by the client. Okay, and an example that we've actually conducted a proactive campaign for a client is where the client has designated certain budget for us in the Asia Pacific region, and we have to report to the clients on a monthly basis on the status of our matters with the clients. Particular investigation firm is appointed to assist on the evidence procurement, and then from each jurisdiction, we will provide a plan, an enforcement plan to the clients, and then we'll proceed to execute that plan. I actually think that this transcends all industries. It's always a question of whether you want to plan right at the beginning, or you simply adopt a reactive approach.
I mean, the difficulty about having a reactive approach is that quite often you end up chasing your tail. For example, I've been in a situation where a client has taken a reactive approach to a dispute over some goods. The dispute was actually in Switzerland. The counterparty was in Australia. We didn't know where the goods were, and you end up sort of chasing the goods around as they get shipped from one country to another. But a proactive approach, of the kind that Andy works on, allows you to sort of be a step ahead of the game, so that you can ring up one of the partners in a different office in a different jurisdiction quickly and perhaps get a freezing order over the goods, the products. But if you don't have that sort of proactive setup and there's not that sort of level of cooperation, it's harder to sort of get ahead of the game and make sure that you can sort of freeze the very thing that the dispute's over.
I think in relation to enforcement, you frequently see two facets, and one is for counterfeiting. The other one is in civil infringement. In both aspects, many of our clients are now beginning to see a lot of cross-border disputes, and the problems transcends just the problems of a single country. So let's take counterfeiting as an example. You're always concerned about the supply chain. So whether you're targeting the infringer at the retail level, the distribution level, or the manufacturing level, if you were to adopt a more holistic approach, you're really solving the problem. Whereas, if you are just doing a very reactive approach, you're just focusing it on, let's say, retail, and you're not dealing with the other aspects of the problems. On civil infringement, let's take patent infringement. As we know, most intellectual property rights are jurisdiction in nature. So the fact that you have patent protection over in Singapore, is likely to mean that you have patent protection over in Sydney and some other countries as well. So we find that if there's infringement in one particular country, now with multinational corporations, you are likely to have infringements, that same infringement against the same defendant in a number of jurisdictions.
And on the flip side, if you don't take a proactive approach to something like patent risk, then you run the risk of developing a technology, rolling it out, unaware that there are already patents that cover some of the processes you've used, and that can result in you facing a lawsuit, having your product or your service stopped until that's sorted out. And I mean, obviously in that kind of scenario, that's sort of an extreme, but had you looked at the patent issue up front, considered it from a number of different countries to make sure that in your key markets you weren't infringing, well, you'd have a very different outcome.
I think this is all part of the government's plan to turn Singapore into an intellectual property hub. The plan probably had its genesis after SARS, and what the country proceeded to do was to augment the laws. And as Andrew had mentioned, it's been a series of strengthening of the laws. And the government has also adopted, a very proactive stance towards enforcement. For instance, we even have a private prosecution regime, and this permits rights owners to prosecute counterfeiters in relation to trademarks as well as copyrights. All this, really sets the framework to allow for investments, as Andrew has mentioned, to come into the country. I suspect so, yeah. I think in terms of protection of companies' intellectual property rights, they'll find it very appealing. They'll be reassured that the infringers will not get away lightly, and that their intellectual property rights will not be appropriated by third parties. I think with Asia driving economic growth in the last 2 years or so, many companies are becoming more aware. If you were to look at the countries like China, South Korea, India, there's a strong focus towards growth in technology as well as growth in creativity. And with growth in these two areas, it's very natural that you will create intellectual property. There's a consequential need to protect that intellectual property. Companies are then becoming more aware of their intellectual property rights. So they begin to protect those intellectual property rights and then begin to enforce those intellectual property rights. I think for our firm, Baker McKenzie, we have for many years been receiving inbound work, and you're absolutely right. In the last, I would say, 10 years or so, there's more and more outbound work, and in the countries I've mentioned, as well as in Singapore or Malaysia or Thailand, as these Asian companies are going outward bound, we're seeing greater awareness.
And probably there's also an increasing likelihood that the client that comes in the door will be equally a domestic company trying to enforce its rights rather than necessarily a foreign company wishing to enforce its rights. So that gives an indication of an awareness and a willingness to sort of enforce intellectual property rights at the sort of domestic level for many countries.
I think those, as I mentioned before, those countries who encounter growth in areas of creativity as well as technology, they tend to be the ones. They have a vested interest, to protect their intellectual property rights. And so, quite naturally, you see these countries taking steps to protect as well as to enforce. If you were to look at the WIPO trade figures, the WIPO figures in relation to patent applications over in 2010, at least 2 of those countries were featured amongst the top 15 countries that filed the most number of patent applications, and they were South Korea and China.